All right. All persons having business before the chief judge and associate judges down to the district. And the court, this needs to be seated and come to order.
Good morning, everyone, and welcome to the District of Columbia Court of Appeals. This argument, which is first this morning, will be a hybrid argument. We have one counsel participating remotely. We have two matters set for this morning. The first is Meta Platforms versus District of Columbia. I am joined this morning by Associate Judge Joshua Deal and Senior Judge John Stedman. So, counsel, are you ready to proceed?
Yes, good morning, and may it please the court. My name is Catherine Carroll, appearing on behalf of Meta Platforms. I'd like to thank the court and the staff for accommodating my remote appearance, and please do let me know if you have any trouble hearing me. And with the court's permission, I'd like to reserve 3 minutes for rebuttal.
All right, thank you. You're free to proceed. And you can hear us?
Yes, I can hear you just fine, thank you.
All right.
Your Honors, this case concerns the enforceability of one request in the district's administrative subpoena. Meta has already produced substantial information, documents, and one witness deposition in response to other requests in the subpoena. But the particular request at issue before the court is unlawful under both the Stored Communications Act and the First Amendment. I'd like to begin with the statutory issue.
Could I ask a preliminary question about jurisdiction here?
Mm-hmm.
We do have some cases indicating that in a discovery request, which is non-final, it's generally not appealable. Here, the parties have consented. Can you just tell us a little bit about why we should be assured that there is jurisdiction to proceed?
Yes, so Your Honor, in the case of an administrative subpoena, unlike other kinds of discovery matters, with an administrative subpoena, the enforceability of the subpoena is the only proceeding before the court. So a decision to enforce the subpoena concludes the entire judicial proceeding, which is why this court in Crane and the DC Circuit in Gay versus Kemp have held that, unlike many typical discovery contexts, enforceability of an administrative subpoena is immediately appealable because it is effectively a final decision. There's nothing else happening in the court, in the superior court here. And that's the case here. We simply have the district's administrative subpoena and nothing else before the superior court.
And the parties have consented, so there's no dispute.
That's correct, yes. Looking at the statutory issue, the Stored Communications Act sets out detailed rules the government must follow when it seeks to compel disclosure of electronic communications. Those rules specify explicitly what the government may demand using only an administrative subpoena. They specify explicitly when user consent alone provides a sufficient basis to compel disclosure. And they specify explicitly when there's an exception to the rules for public content. But when it comes to the contents of electronic communications, Section 2703 is unambiguous. It states for both public and private content that the government may require disclosure of the contents of communications, quote, only pursuant to a warrant. Now, Congress imposed those requirements unique to the government because it recognized that the government, unlike private litigants, has enormous power to conduct surveillance with significant consequences and potential for abuse. Well, and it recognized—
it's true that 2703 applies only to the government, but nobody else under the Stored Communications Act is ever allowed to compel the production of electronic communications, right? There is a provision that says here are instances where the government can compel them. There is
That's
no
correct.
provision that says anybody else can ever compel them, right?
That's correct. This court in the Pepe decision considered the enforceability of otherwise valid legal process brought in that case by a criminal defendant. And it looked to whether Section 2702, which governs voluntary disclosures, posed a barrier to the provider's compliance with that subpoena. And it explained that where there is valid legal process and where a 2702 exception permits disclosure, the provider must comply. But
Right. But I mean, I guess to get to the heart of it is you're reading a statute that says nobody gets to compel disclosure other than the government in these instances. And saying, well, in fact, everybody but the government gets to compel disclosure in this whole host of other instances, which seems to flip the whole statutory regime on its head. If the CPPA has private enforcement actions as well. If the district has an individual join them as a plaintiff in their quest against, if somebody had brought a suit, an individual plaintiff has brought a suit, there's no question they could get access to all these materials, right?
So I think that would be true only under very specific conditions that don't apply in the case of the government, and that I think help to explain why it's sensible to distinguish between the government and private litigants. A few key differences. Number one, as I alluded to before, is sort of the resources and potential consequences of the surveillance by the government as compared to private litigants. Congress recognized that in the legislative history. A second difference concerns sort of the threshold hurdles that would have to be crossed.
And I don't mean to cut you off, but could I just get a yes or no? Is there anything in request 2 that you think a private litigant, I'm sorry, is there anything in the grant that the Superior Court limited its grant of the subpoena to public postings? Do you agree that if there were a private plaintiff in this case, they would be able to compel those via subpoena?
So it is actually not limited to public postings, and I want to come back to that. But to answer your question, I think with respect to the Stored Communications Act, there would not be, if a 2702 exception applies, there would not be a barrier the way there is for the government. I think there could be First Amendment issues. And importantly, with a private litigant, that private litigant also would not be able to enforce this subpoena unless it first demonstrated its standing, survived a motion to dismiss, and agreed to I think a fairly robust protective order would have to apply in a case like this. Whereas the government does not have to establish that there's any merit to its investigation at all, does not have to establish any harm, and faces no constraint with respect to further disclosure or how it uses the material once it obtains it. Those are significant differences between the private litigant and the government.
I don't understand why that's true. Did you ask for a protective order for anything that you handed over? Why couldn't you get that against the government?
So, well, the Stored Communications Act does not provide for any such thing. And in fact, soon after the subpoena was issued here, the government represented to Meta that it would be willing to accept limitations of confidentiality to the extent it agreed that anything was confidential, but underscored that it might be subject to obligations under the DC Freedom of Information Act actually to disclose potentially some of the material that's turned over. So looking back to the plain text here, Congress plainly wrote Section 2703 specifically to limit government compelled disclosure. Throughout Section 2702, Congress repeatedly distinguished between disclosures to private parties and disclosures to the government. So there's no question.
But 2702, excuse me, counsel, doesn't specifically exclude government entities, does it?
It does not.
I know 2703 references government entities, but 2702 doesn't specifically exclude government entities.
It does not.
The
But
government's interest different than a private citizen's interest here in these under 2702.
so I want to be clear, our position, and I think the distinction that this court drew in Pepe between private legal process and government legal process The reason why it's significant that it's the government that's requesting here is not because of some limitation in section 2702. The reason it's significant that this is the government is because Congress wrote express rules specific to the government and said unambiguously that
Right,
this is
but
the
by that
regime.
same token, I'm sorry, Ms. Carroll, by that same token, since Congress was so explicit about the government in 2703, they could have been equally as explicit in 2702 to say that it only applied to private citizens and not the government. There's no exclusion in 2702.
There's no exclusion in 2702, but I think the entire statutory scheme, it's manifest in that scheme that there are enumerated exceptions to the prohibition on disclosure and that there are no implied exceptions. And so, for example, section 2702 makes an exception for disclosure that is authorized in section 2703. The implication there, and again, this court acknowledged this in Pepe, the implication there is that the authority for the government to demand disclosure comes from, if at all, comes from 2703.
Well, where do you fit the district's subpoena powers?
I'm sorry?
How would you tie in the district's subpoena powers here? Because 2703 references search warrants or warrants under criminal probable cause under 2703. The district's subpoena powers are broader and are applicable in administrative and civil proceedings. So where would you put that in the statute?
Right.
It's
So
not specifically enumerated.
it is specifically enumerated in section 2703 subsections B and C2 specifically reference the power of the government to demand disclosure using an administrative subpoena. It specifies using an administrative subpoena, the government can get basic subscriber information, or, and this is in a provision of with respect to contents that is not really in use anymore because of the Fourth Amendment holdings, but section 2703B says that the government can demand disclosure of contents using an administrative subpoena only if it provides prior notice to the user. So I would submit that that provides very strong evidence indeed that Congress specifically thought about what should the government be able to get using its administrative subpoena powers, and it limited the reach of that power to specific enumerated categories that do not include.
Including everything that's at issue here though, right? I mean, it's posts that are, if it's more than 180 days old in storage, which I take it is everything that the district is requesting. It might not be, maybe there's some things that fall within 180 days. Then they'd be able to get it with subpoena and prior notice. And I assume the only reason why they're not invoking that provision is because it's tough to provide prior notice when they don't know who the posters are. But nothing in the Sixth Circuit case that you're citing says, that 180 days is no longer of any force in the SCA. It says it doesn't make sense as a Fourth Amendment principle. But this whole construct doesn't make sense as a Fourth Amendment case, because again, and you're going to tell me why I read the Superior Court's order as applying only to public posts. You took some issue with that description. I'd like to hear why.
Yes.
So that's one question. The next one is, the district makes this argument and made the argument below that it really doesn't make any sense to apply the SCA to public posts, period. And I see a fair bit of support for that in the statutory text, including, in 2702, it talks about the intended recipient or addressee of communication. It's tough to know what that means if it's a public post. So A, tell me why you think the Superior Court's order isn't limited to public posts, and B, tell me why you think it makes any sense to apply the Stored Communications Act in light of its text and history to public posts?
Yes, I'm happy to take on both of those. With respect to the factual point, the scope of the subpoena, the request here applies to, it includes content that was never publicly available in the first place and content that is no longer publicly available. So looking at, and this is reprinted at page 26 in the appendix, Judge Epstein rewrote the subpoena. Of course, on its face, there's plainly no limitation to public, but Judge Epstein rewrote that to apply both to publicly accessible posts, that is, posts on Facebook that are generally accessible to any member of the public. Even if you don't have a Facebook account, you're not on Facebook, you can still find it there. There is no barrier to your seeing the content. It includes that, and also includes what he described as nominally private posts, which are to say posts to, one's Facebook account or a private group, where, as he put it, there's just so many people, you have so many Facebook friends that it reaches so many people that we may as well treat it as public. But the case law, and I'd point to the Ninth Circuit's decision in the High Q case and the district court decision in Elling, among others, explain that, consistent with the legislative history, public for purposes of the Stored Communications Act means only truly public. You don't have to log in, you don't have to provide a password, you don't have to be admitted to a group.
Can you point me to a place in your briefs where you're making this argument? I mean, as I understood Judge Epstein's ruling, it was you guys work it out amongst yourselves. Beyond the wholly public posts, you figure out what is broadcast widely enough to be considered public under this subpoena. And I don't recall seeing you take issue with that. So where is that?
So we addressed that. The government did not argue that the SCA is inapplicable to private content until its brief in this court. And so in our reply brief, we address that, and we explain early on in the reply brief, both that that's wrong as a legal interpretation of the SCA, and I'd like to get to that point, but also that as a factual matter, the predicate of that argument is non-existent here, because although the court left it to the parties to work out the precise meets and bounds of the non-public category, he clearly states at page 26 of the appendix that this would include both public and nominally private posts. And frankly, Your Honor, even with respect to content that was truly public when it was first posted, I think it's important to bear in mind here that we're not talking about content that is sitting up there on Facebook today. We're not talking about anything that's been permanently preserved in the public record. We're talking about posts that might have been posted for a fleeting moment before the, by virtue of the moderation policies, they were removed. So the reason why the government is bringing this subpoena in the first place is because it's not public. And what they want Meta to do is to compile a database of every user that has posted content on a particularly controversial topic. And the reason why I think that makes sense, we know from the legislative history and from Section 2511 that Congress was focused and did think about the difference between public and private communications platforms. And it created an exception to the prohibitions against interception and access. That's the text, the plain text of 2511 says it shall not be unlawful to intercept or access from a truly public, readily accessible to the general public communications platform. But it did not create any such exception in Section 2703.
Could you give an example of what you think of as a truly public platform?
So what Congress had in mind at the time, and bearing in mind that it's been more than 30 years now since the statute was enacted, so a very different time in terms of what the precursors to social media were. But what Congress had in mind then were sort of the emerging concept of what were called electronic bulletin boards, which were, essentially web pages that any person could access, read, and comment on. And as Congress was extending the prohibitions of the Wiretap Act and creating new protections for electronic communications, it said, we want to make sure not to sort of strangle in the cradle these new emerging platforms for truly public communications. But it limited that exception to the prohibition under the Wiretap Act and the prohibition in 2701 of the Stored Communications Act said that there's an exception for unauthorized interception or access. The government here is not trying to intercept or access these posts in the terms that the statute uses. It's not trying to, trespass on Meta's servers. It's not trying to log into Facebook and find this content itself. It's using legal process to demand that Meta provide the list of users for it. And that is an exercise that is governed explicitly by Section 2703. And we know that Congress thought about public, did not make an exception. And when Congress draws a line that, balances competing considerations, it is true that sometimes that ends up covering situations that are maybe not in the heartland of the concerns that Congress was responding to. But I actually don't think we're that far removed from the heartland concerns here when we think about what this request is doing. This request is saying, give us a database, a watch list of every user that has posted content on a disfavored topic. Here it's misinformation about COVID-19 and COVID vaccines. In another case, it could be, in a state where, let's say, abortion is unlawful. Give us a list of every user who's posted content about where to find abortion care in our state. Or in a state where assault weapons are unlawful. Give us a list of every user.
Counsel, I take the parade of horribles, but your position is that you're free to hand that over anyway, right?
So our interpretation is that both the Stored Communications Act and the First Amendment preclude the enforcement of the subpoena, and particularly given the infringement here on users' First Amendment rights, it's not a matter of.
I think it's a yes or no question. Is Facebook, is Meta free to hand all that stuff over anyway?
With when a 2702 exception applies, the barrier to voluntary disclosure.
And you think it does, right? I mean, all of this.
We haven't.
Yeah, you haven't put up any fight that 2702 exceptions don't apply. So, I mean, all of these, it rings a little hollow to me to hear you say, these privacy protections for the users are really important, when Meta's position is we are free to hand that over, and in fact, regularly do hand it over in cases that do not implicate our own wrongdoing, which I mean, has this come up? Can you point me to a case where somebody else was being investigated, a 2702 exception applied, and Facebook refused to hand over the sought after materials?
Your Honor, Facebook responds to legal process routinely all the time when the government provides a warrant. This case is the first case that I'm aware of in the history of this statute where a court has said that the government can compel this. There are a couple of other cases that make clear the government can't do this. So for instance, there was a case involving Twitter out of the state court in New York, where the court, first went out of its way to say, we're talking here about publicly posted tweets. So there's no Fourth Amendment expectation of privacy, but nonetheless, the statute says the government must obtain a warrant. And so it required a warrant.
Except it did order everything that was more than 180 days old to be handed over in that case, right?
Only because the government had complied with the requirements of Section 2703D in obtaining an appropriate court order.
I mean, those requirements are pretty formalistic, right? It's notice. That's all that's required.
No, that's not correct. For Section 2703D, which was the kind of order that was at issue there, the government must go to the court to make a showing of specific articulable basis to believe that the records will include material that will be material and relevant to an ongoing criminal investigation. So there was indeed, significant legal process in that case that the court said was required. And I think it's significant that in the 30 plus years that this statute has been in existence, we've never seen any indication that the warrant requirement is somehow stymieing government civil enforcement or investigative efforts. And I think that's because.
So if I can understand your position, it essentially is the only mechanism that the government can employ in order to get any communication covered by the act, whether, no matter how private or how public it may be, 703 is the mechanism and 702 has no relevance when the government is involved. Is that that's your bottom line position, isn't it?
Yes, that it's our position, as the plain text states, that the government may
Can I just
require
follow up
disclosure. Yes.
briefly on Judge Stedman's question? So your position would be that if a private entity or private citizen had made the same request under 2702B3, you would have turned over the same information.
I don't
That's
think we
being
would have,
requested now.
we would not have
Under
turned that,
exception.
we would not have turned that over. First of all, you would, a private litigant can't, we don't even get to a conversation about a subpoena with a private litigant unless we have ongoing litigation. They've signed a complaint under Rule 11, they've established their standing, and
Would a
they've
private
scribed a motion
citizen-
to dismiss.
Would a private citizen need a subpoena under 2702B3?
Yes, for certainly they would need a subpoena. And I think even assuming that the rationale of Pepe would extend to civil litigants, I think that in that case, again, there would be significant threshold hurdles that a civil litigant would have to pass. And again, I don't think there's any question that a civil litigant could never get material like this without a very robust protective order, whereas here there's no constraint on the government disclosing the information here either publicly or to their colleagues down the hall who might decide they want to investigate the users or conduct some other investigation.
Was a protective order sought here when the government sought to exercise its subpoena powers?
There's no legal basis to do that. We've asked the government, please keep it confidential, but that's a matter of the government's grace. And as I mentioned earlier, the government was careful to qualify its willingness to accept such an agreement and invoked as well the DC Freedom of Information Act. I want to go back to this point about, user consent, and this is public, and what's the big deal? I think there's a few points to keep in mind on that. One is, because we're dealing with a plain statute here, Congress already wrote out all of the rules in great detail. And there's not really room here to say, well, here's an instance that doesn't necessarily make as much sense as some of the others, so let's carve out our own rule. That's not how it works with statutory interpretation here. But I would point also to Section 2703C1C, which specifies that with respect to records pertaining to a subscriber or customer, if the government has user consent, Congress explicitly said consent is good enough. If all you're seeking is records, you don't have to get legal process. You can just rely on the consent of the user. That provision would be completely superfluous under the Superior Court's reading of Section 2702. And I think it illustrates even more clearly that Congress was very attentive to the circumstances in which user consent should or should not be a sufficient basis. And again, why does it make sense to say that you're talking about something that was publicly posted at one point? It's not there anymore, but at least when it was originally posted, there was some degree of consent. But I think the insight of cases like the Supreme Court's decisions in Carpenter and in the Reporters Committee decision, that's the rap sheet decision, recognize that people don't lose all privacy interests just by venturing out into the public. And so a person who goes about in public, they can be seen, the police could follow them, the police could see them, but the courts still recognize that there's a difference between that and a compilation retrospectively cataloging one's public movements over a period of time. And so
again, counsel, the reason why this appeal rings hollow to me is because you're standing here saying you are free to do that for any one of your users. You're free under 2702 to hand all of that over to the government whenever you want. So to invoke sort of people's expectations of privacy under the Fourth Amendment, which does not bind you at all, as sort of a shield for Facebook in a way that you were free to hand them all over. I mean, I guess it just brings, I think it would bring your users cold comfort to learn that their protections are not in the Fourth Amendment, and they're not actually protected by the statute at all. Their protections lie purely at the whims of Meta and whether or not they feel like handing it over or not. And that is a surprising regime.
So maybe I can take that on in a couple of ways, Your Honor. One is, we know that Congress drew several exceptions to the prohibition that it called voluntary disclosure and did leave at least some discretion in the hands of the provider. Now, when there is valid legal process, we don't think the provider would have discretion to refuse to comply. But the question here is whether the legal process is valid in the first place. And I'd like to take a little bit of issue with the notion here that this is using the Stored Communications Act as some kind of a shield. As I said at the outset, Meta has already provided quite a lot of documents and information. We made a witness available for a lengthy deposition. And throughout the course of this litigation, before, during, and after the litigation in the Superior Court and since, Meta has been engaged in good faith discussions with the government, pointing out alternative avenues that the government could pursue. For instance, you wouldn't have a Stored Communications Act issue here at all if the government had simply asked for de-identified information. There's no reason it needs the user's identities here. And if it had not tied its request to user content, we wouldn't be talking about the Stored Communications Act at all. So this is not a question of a shield. Meta has provided a lot of information. It stands ready to continue cooperating with the investigation. The issue here is that we have a statutory scheme. And again,
Ms. Carroll, if I could stop you just briefly in the midst of this response for clarification. In talking about the statutory scheme, I know that you want to focus us on 2703. And at the same time, you're talking about process needed for the government to get access to certain documents. When I took you back a moment ago to 2702 and asked whether a private citizen could get a subpoena for the same information, you said that they would need to go through legal process and there might be some hurdles. What hurdles are missing in the legal process under 2702 that would be different from what a private citizen would need to do versus what the district has done here under 2702?
So 2702 is not a source of authority for anyone, public or private litigant or government, to compel disclosure. 2702.
You just said a moment ago that a private citizen, or I thought you did, I'm sorry, I misunderstood, that a private citizen could make the same request under 2702.
Maybe I can
They would need a
clarify.
subpoena, and there would need to be some legal process. I thought that's what you said.
Yes,
Here,
maybe I can
district has
clarify.
made this request for disclosure under 2702 with a subpoena. There has been some legal process in the Superior Court under Judge Epstein in a very lengthy order responding to their subpoena request and making a determination. What's wrong with that legal process? And would it have been a different process had it been a private citizen under 2702? I know you think it doesn't apply to the government here, but I'd like to hear your thoughts.
Yes, so maybe I can clarify my earlier comments. Section 2702 is not the font of authority. It is not the thing that authorizes anyone to compel disclosure. 2702 is a prohibition on disclosure, and it includes certain exceptions. When a litigant, whether it's government or civil litigant, demands disclosure pursuant to the authority granted under some other source of law, for instance, a Rule 45 subpoena, a Rule 17 subpoena by a criminal defendant, an administrative subpoena, a warrant.
2702
Correct.
B3 exception, which deals with consent.
That's right. And where that consent exception comes into play, and I think this court's decision in Facebook versus Wint might be helpful, in disentangling this. So in Wint, the criminal defendant had a valid subpoena, but no exception in 2702 was available. And this court held you can't get the material because there's no exception. 2702, you come to court with legal
But there is an
process that
exception. There is an exception under which the parties proceeded here in 2702.
Right, and the exception removes a barrier that would otherwise preclude compliance with valid legal process. But the validity of the legal process in the first place is not governed by section 2702 does not authorize the government or anyone else to issue legal process. It creates exceptions that permit the provider to comply with legal process when legal process is valid. But
Okay.
it's a question
I
under
take your
section
point.
2703 as to whether the legal process is valid when you're talking about the government.
I
I
take
hope-
your point.
Does that
And I know
clarify?
we've taken you well over your time, and I know you have some time for rebuttal. So unless there are any further questions from my colleague, I'd like to hear from the government at this time. And we'll make sure to reserve your time for rebuttal. Ms.
Thank you.
Thank you, and may it please the court, Ashwin Pathak for the District of Columbia.
All right, good morning.
Good morning. I'd like to just, so the district seeks information from Meta to determine whether its public statements about its COVID-19 vaccine misinformation policy were false or misleading to consumers. And let me just start with a couple things that my friend on the other side just said, which I think are really important to this case. The first is that, as far as I can tell, she admitted that there is no barrier to a private party seeking these documents via subpoena under 2702. And the second is she admitted that Facebook could, on its own volition, turn over these very documents to the government if it wished to do so under section 2702. I think those two concessions are really important here because it basically, in their view, would place the government in a unique category where, despite following all of the legal processes, district law under the CPPA, and meeting the Morton Salt standard, issuing a valid subpoena, nevertheless, we would be precluded from getting what a private party could get and what Facebook itself could turn over. And I just don't think that makes sense under both Congress's intent when it passed the Stored Communications Act and the text of the statute. And let me start with Congress's intent. Obviously, this statute is 30 years old. It doesn't fit perfectly onto the way that the internet functions today. But I think we can look at a couple clues in the legislative history, which is that Congress really did understand the distinction between private and public posts. As to private posts, Congress was focused on emails, which of course exist today, and you can analogize to other private communications online. And as to public posts, Congress specifically talked about electronic bulletin boards, which were accessible to the public, which anybody could respond to or see. That is exactly the same as a public post on Facebook today.
So in other words, your position essentially is that 702 provides what anybody can get, including the government.
Correct.
703 says the government can get more than a private party if they follow 703.
That's exactly right.
That's what you're talking about, right?
That's exactly right, Judge.
703 adds nothing to the government except more power than it would have otherwise under 702.
Well, I'm not sure that's exactly correct. I think as to private information, 2703 does explain the ways in which government can get that particular content. And so, for instance, for private content that's less than 180 days old, where the government is seeking the content of communications, we would need to go down the pathway of getting a warrant, even if under, say, the Fourth Amendment or other processes, we might have other ways to get it. But I think for public information, you are correct. The government's argument here is that governments are not subject to some special rule for public content that wouldn't apply in the case of a private party, or where Facebook could just turn over that information on their own through any 2702 exception.
Do you think the act applies at all to situations of a public nature?
No, and I think
I mean, suppose the posting was on Facebook, I want everybody in the world to read this particular document.
I don't think that the act would apply at all. And I would just point to a couple different things. The first is the 2511.
Let me ask you, I'm sorry to interrupt, but it's going around in my head. I should think that what the government, Congress is trying to do here is trying to sort of, in a way, analogize the communication system that has come into effect with emails and so on, to the old post office rules, where first class mail was sacred, virtually. What happens if you mail a postcard? Do you have any idea whether or not that's covered by whatever rules control access to first class mail?
I am not 100% sure. I believe, if I'm recalling back to when I've last looked at this, that a postcard that's openly visible to anybody would not have Fourth Amendment protections in the same way.
Did you waive your First Amendment rights when you write a postcard?
I
Hello,
think that
sweetheart. How are you? I hope you're having a great time. I miss you something awful.
I
Love,
think
John.
if you have a public post, if you have a public message like that can be viewed by
Okay,
anybody.
well, I don't mean to distract you, but anyhow, to go back to the question, your view is that the act does not apply at all to any, shall we say, public? Because why? Because of the section that says if you intend to make it public?
Right. So
But if that's so, what does that add to the?
well, I think a few.
Well, I see, that could be a private communication.
Exactly.
That you would say, okay, fine. Yeah, okay.
Exactly. That's exactly right. And just to take the second question that you asked, I think it is exactly right that when Congress passed the Stored Communications Act, it was intending to overlay Fourth Amendment protections in the digital sphere, where otherwise the third party doctrine would essentially have, that information be open season. And so we totally agree. It was placing a Fourth Amendment valence on the digital sphere for communications content that's stored by a third party company like Facebook. But under the Fourth Amendment, as far as I can tell, the other side agrees that there really would be no barrier to the government getting information that is totally public
Well,
for
but
the world
they
to see.
agreed to a point, and your argument resonates with me to a point. And I think the point where I get a little concerned is if you're just talking about the Facebook post that are public or as Judge Epstein, I think, said, only minimally private. That resonates with me. Why should the district government or any government entity have to do more than a private citizen to get those, which are already in the public sphere largely? But when you're talking about the senders, the identity of the senders of some of these posts, and in this case, the district's interest professed is a noble one, perhaps of misinformation around COVID and COVID vaccines, and you want to know who posted such things. That takes on an ominous feeling to me when, as my colleague called the parade of horribles that Ms. Carroll listed, of other less noble, but perhaps under the statute, if we rule in the district's favor, as allowable under this statute. What do you say about that? I mean, why do you need to know who posted these things versus just get access to the post as public information?
A few responses.
Sounds a little big brotherish to me.
I understand, Your Honor. I understand, Your Honor, and let me try to explain why we need that information and why it shouldn't be
To
problematic.
hunt them down and punish them? Is that a valid
So,
interest?
Chief Judge, I think what we're doing here is we're investigating whether or not Facebook is complying with its own publicly professed vaccine misinformation policy. And the reason we need the actual identities of the users as they publicly present themselves on Facebook is because there are actually very well-known purveyors of vaccine misinformation. We cite some of these sources in our brief, they're in the briefing below. And so these are situations where you basically have a handful of people that are sending around the vast majority of COVID-19 vaccine misinformation on Facebook. ProPublica has looked into this, NPR has looked into this. And so what we want to know is, when did Facebook know that these particular individuals are the ones that are sending around the vast majority of COVID-19 vaccine information? And then when did they do something about it? Is it only when it became publicly available knowledge that it was these particular individuals that are sending around the information? Or was it when they found out, and after the fact that they had actually put forward this policy about vaccine misinformation? And just to ask to your point about whether, this brings about some kind of Big Brother type of issue, I don't think that's really happening here. And it's because what we are seeking is just the identity as people have identified them on Facebook. Now, Facebook has a policy that says that on that platform, you actually need to use your real name. But some people obviously don't follow that policy, and we have no quarrel with them giving us simply the publicly presented identity of these individuals. And the only thing we are seeking is individuals that have posted publicly, not individuals that have posted privately as to vaccine misinformation. For public misinformation of that type, these individuals simply do not have a reasonable expectation of privacy or a First Amendment right to that information not being widely disseminated because they widely disseminated it.
Can I just take you back to your textualist argument? So you say, these public posts are not covered by the SCA. It's not totally clear. I mean, I understand you have sort of a mosaic theory of, just read the act, understand this was 1986, this meant mail, read his history, and that I take your point. But if you wanted to drill into the statutory text, it strikes me that you have a few options, and I'm not sure I'm hearing any of them from you. One is you could say, well, look, this really is an electronic communication as the act envisions. Another one is, look, when Facebook hosts public walls, they're not providing an electronic communication service as the act envisions. Another one is, well, they're not holding it in electronic storage, which is incidental to transmission, which is a textual hook in the statute. Instead, I'm getting sort of a mush. Could you walk me through the textual argument of why you think public posts aren't included? I mean, do you think they're electronic communications under the act?
We do think they're electronic communications under the act if the act applies to public posts, but I would just push back against that. So let me just point to a couple textual sources for our argument, which I think do need to be read in the context of the act's intent, Congress's intent when it passed it, and the legislative history. But let me just point to first 18 U.S.C. 2511 2GI, which we of course pointed to in our brief. And in that provision, it references the entire Stored Communications Act, Chapter 121 of this title, and it says that access is permissible if a particular communication is configured so that such electronic communication is readily accessible, to the general public. And I think that is this situation. And the other side says, well, that doesn't apply because it's only related to access.
Well,
but
they might have a more affirmative point, which is it tells you right there that readily accessible to the general public does not preclude something from being an electronic communication or being transmitted through an electronic communication system. So that sort of those overlays of the act would apply to public posts.
Right. Well, yes. So I think basically what this provision is saying is that the entire act doesn't apply to public posts, essentially.
You think they'd hide, the elephant in the mouse hole in 2511 G2? They'd say public posts are out of it?
Perhaps only because I think it was so obvious that the Fourth Amendment doesn't apply to those kinds of posts. And throughout the legislative history, they talked again and again about electronic bulletin boards just not being a part of this at all. So,
is it true that the Fourth Amendment doesn't apply to those types of posts? What would happen if I hung a banner from my balcony for the whole world to see, conveying some message some political message that I wanted to get out there? And, 5 seconds later, I said, you know what? I changed my mind and I fold up the banner and I hide it in my bedroom. Are the police free to come and confiscate that banner without any Fourth Amendment restrictions against them because it was up publicly for a moment?
No, and that's because, of course, the home has special protections under the Fourth Amendment. But I think the
Okay.
analogous situation in that hypothetical would be the next door neighbor takes a picture of that post and has the picture and then wants to turn it over despite there being some, 2702, 2703 type of.
Except isn't the analogy
situation.
that the neighbor doesn't want to hand it over? I mean, here, the person who's in possession of that picture is really Facebook. They've got the record. And
Right.
they say, I don't want to hand it over. The government couldn't force that neighbor to hand it over, I take it.
Right, but I think that the government could seek, for instance, an investigatory subpoena of that photo if it had reasonable cause to think that a particular violation took place. I mean, it's hard to think what a banner would be, what violation would be happening with the most pure First Amendment type conduct like a banner, but I think that would sort of be the analogous situation.
What do you make of other provisions? Part of my questions to your opposing counsel were why the district government couldn't access and make this request similar to a private citizen under 2702. And her response, as I understood it, was that 2703 offers more specific, or the only specific, ways in which a government entity can seek this kind of information. But there are provisions under 2702. B8, which allow disclosure to a government entity if there's a danger, serious danger or serious risk for law. It seems to suggest for law enforcement purposes, which your motives sound somewhat in that. Law enforcement, you want to make sure Facebook is doing what it said it was doing to presumably protect the public. Why wouldn't you be limited under 2702 to those other provisions under 2702 or 2703, which seem to speak to some type of enforcement means for the good of the public, which is what it seems in part like the district's interest is here?
Sure, a few different responses to that. So the first
That
is
was a
that,
few different questions, so I guess it warrants a few different responses.
and so the first thing I just say is, as far as I can tell, they have agreed that a private party could issue a subpoena for this particular information and get it under the B3 provision of 2702. There's no provision in 2702 that allows a private party to do that. Instead, what's happening there is that a private party is just going about ordinary subpoena process. And this court in Pepe said that when you're going about that ordinary subpoena process, everything else is above board and lawful. The Stored Communications Act isn't going to pose a barrier if a 2702 exception applies. I think that it should apply to the government, and let me explain why. Of course, 2703 has certain heightened requirements for the government, but we think that those mostly apply only to private information. And I think there's a lot of reasons in 2702 that we can understand why that provision isn't sort of hermetically sealed in the way that they're suggesting. So you pointed to 2702 B8. Let me also point you to 2702 B6. That provision actually requires a provider like Facebook to turn over information relating to a child pornography violation to the government. That, if you look at the cross-reference there, that's actually a requirement. It's not a may, it's a must situation. I'd also point the court to 2702 C6. I think that provision is actually very indicative here because it says that for records, Facebook can turn over that information to any person other than a governmental entity. And I think that suggests that Congress knew how to specifically target the government as a carve out from one of the exceptions in 2702. And it didn't do that throughout. In fact, there are many provisions in 2702 that have these direct the information that Facebook can release to particular individuals. And 2702 B3 doesn't have that.
And do you have a response to 2703 C1C having a consent exception in there? I mean, allowing the government to compel disclosure, which would seem to be entirely redundant of the 2702 exception if we accepted your reading?
I think, there definitely is some redundancy there. I think obviously we think 2703 applies to private information. So as to private, take an email. for instance. I think, and if you look at an email, I think all of the 2703 provisions would apply. So you could get a warrant for an email that's less than 180 days old. You could get a warrant or a court order or an administrative subpoena for an email more than 180 days old. And you could get records surrounding that email under the 2703C provisions, including having that consent exception. So I just think the way to think about these provisions isn't so much like each sort of nitty-gritty provision, but rather the 2703 as a whole is focused on getting private information, and that for public information, Congress just did not expect for that entire regime to apply because of its explanation of the difference between a public bulletin board and emails. I just think that's the way they were thinking about this statute.
I tend to agree, but I'm still, you know, besides you started walking me through your textualist hooks for that, and you said 2511G, which is the one you talked about in the brief. I think there's some indication in 2702 when it talks about the recipient and addressee of an electronic communication, where, you know, language like that just doesn't make a whole lot of sense when you're talking about a public post. And also it would seem that a recipient and addressee, if it's a public post, includes everybody, which means anybody can send to it. And then it really doesn't make a whole lot of sense. But I, just in case I cut you off earlier, I probably did. Did you have other sort of, I take your sort of sweeping approach to, we read the whole thing and then look at the history. They weren't thinking about the advent of Facebook that didn't happen for another 20 years. They were talking about these really archaic, what looked sort of like mail delivery service, but electronic systems. So, but the textualist hook is quite tough, because if it is an electronic communication service, and this is electronic communication that's in storage, on the plain text, you know, it looks like it's all covered by 2702 and 3. But you're telling me not, and other than sort of a general appeal to the structure and like underpinnings of the act, do you have sort of particular areas you want me to look at?
So I think in addition to the 2511 provision that I pointed out to you, I pointed out some provisions to the chief judge that I think sort of suggest that 2702 and 3 are not sort of hermetically sealed provisions, and that Congress knew how to exclude the government from a particular exception under 2702, and it didn't do so for the
those sound to me like totally different arguments. One is these are covered by the act, but it falls within an exception, and the government, you know, can avail itself of those exceptions. That sounds to me to be I mean, that was kind of Judge Epstein's reasoning, which is, yeah, they're covered, but there's been some consent and the government can make use of the 2702 provisions. Okay, I get that. That sounds to me like a very different argument from they're not covered, period.
That's fair enough.
Okay.
I mean, we sort of see the two arguments as two sides of the same coin, but I agree with you. They are obviously analytically different. And there's one argument that 2511 essentially takes out public type posts from the SCA's ambit at all. And then there's the argument that 2702B3 through user consent allows public posts, the government to get public posts or anybody to get public posts like that. We sort of see them as two sides of the same coin. And I just, one additional point on this textual point, you know, there are obviously, I understand that Your Honor is kind of looking for the textual hook. And I think we've offered a few that we think get there. There are obviously cases, you know, I'd point the court to King v. Burwell in the Supreme Court, where the text actually seems really clearly on one side. And the court actually looked in that case to the broader intent structure of what Congress was trying to do in a particular act. And in that case, basically went against what the plain text said to suggest that, you know, funding to exchanges could go to federal exchanges in addition to state exchanges. So, you know, if the court really does feel like it's gotten to a place where it is unambiguously in one particular direction, I would still counsel that the court look to the broader structure of the act. But we think there are a number of textual hooks that can get you there as well. I'm happy to address any other questions. I know we haven't talked about the First Amendment issue, but if there are no further questions, I'm also happy to sit.
All right, thank you.
Thank you.
All right, counsel for appellant, we reserved a few minutes for rebuttal for you, Ms. Carroll.
Thank you. And I'd like to make just a couple of brief points. As the colloquy, I think, has shown, there really is no way around the text here. Section 2703 doesn't say, in addition to 2702, government may also do the following. It says government may require disclosure only in the ways specified there. The consent exception in 2703 C1C, given the government's equation between consent and public, I think further refutes the idea that there's no exception in 2703 for public, unlike the language in 2511, which carves out an exception only for the access and interception prohibitions. And if this court were to endorse the Superior Court's unprecedented departure from the text here, I think that would indeed lead to what the Chief Judge referred to as ominous consequences, bearing in mind that the decision here is not going to apply only when the service provider is the target of the investigation. The statute means what the statute means. And so if this court were to agree that the text does not control and we should instead read in an implied exception to public, even though Congress thought about that and chose not to draw one, it would mean that a government investigating user speech for purposes of identifying a watch list of users who had posted about where can I purchase illegal marijuana in my state? Where can I purchase an AR-15 in my state? Where can I obtain access to abortion care in my state? That government, nothing in the Stored Communications Act would preclude the government from demanding every social media platform to compile that database. That, I think, does go straight into the teeth of the kinds of privacy concerns that are at issue here, notwithstanding that the request includes, in part, some content that was once at one time publicly available.
I mean, except nothing in your reading stops you from complying with that request anyway.
Your Honor, when we're
it leaves the Stored Communications Act. I mean, you keep trumpeting sort of the privacy interest at stake, except I don't have any privacy interest. No individual has a privacy interest in those posts under your reading. It is totally up to Facebook whether or not they want to hand it over. And that's your reading. So it's not like we're protected from the government at all. The individual users are sort of at the whim of what Facebook wants to disclose, which is just a really surprising result. That doesn't sound like a Fourth Amendment protection to me at all. It sounds like my Fourth Amendment rights are out the window, and Facebook, it kind of dictates what the government gets to know and doesn't.
Well, I think that's why Congress wrote Section 2703, precisely because it recognized that as technology advances, there are open questions and uncertainty around the extent to which the Fourth Amendment would apply. And so it wrote a bright line warrant requirement precisely in order to require a warrant, even where a court might not agree that the Fourth Amendment would require one. And we now have a bright line warrant requirement, and the government must.
It's not a bright line requirement. You can hand it over whenever you want. I mean, again, the Fourth Amendment is meant to protect. It was sort of the SCA, as I read it, was meant to extend Fourth Amendment protections to information that sort of necessarily has to be shared with a third party provider. With a electronic communication service, because they're the ones who transmit it. In the same way that I put a letter in the mail, they're going to have access. The post office is going to have access to a letter of mine, and we're trying to extend Fourth Amendment protections to that area. Once you concede that Facebook is allowed to hand over anything that I've posted publicly at their whim, and they want to, the Fourth Amendment protection becomes totally ethereal. It is not a protection at all. Facebook is just in charge of what they want to hand over and what they don't, and that's not a protection at all.
Your Honor, the same thing is true in a traditional search. If I have evidence relating to a crime here in my home, nothing stops me from picking it up and walking down the street and taking it to the police station. That's a very different thing from saying the police, well, therefore, it must be okay for them to come into my home without a warrant.
No, that makes a lot of sense, because you're the person who enjoys the Fourth Amendment protection, and so you're allowed to waive that through consent. But this is more analogous to the bank that holds the mortgage on your house consenting to the government coming in and saying, well, let's let that third party decide when they want to invoke Fourth Amendment protections. I mean, here it's, the individual under your view has no additional protection under the SCA. It's just that Facebook gets to make whatever call they want, which is, again, very tough to reconcile with an act that was supposed to extend Fourth Amendment protections to people. And now it seems to boil down to, Well, and it also extends to Facebook in some circumstances, but they're free to hand it over whenever they want. That is pretty, it's a pretty weak protection.
So all I can say, I think, Your Honor, is that Congress thought about these issues. It wrote a statute in which it specified when is there an exception for public, when is there an exception for consent. It did not write such an exception here. It instead said, quote, only pursuant to a warrant. And I think that language leaves no room for the court to write its own exception. And if the court
Isn't that
did
only
so,
if you, I'm sorry, Ms. Carroll, isn't that only if you, you seem to disagree with opposing counsel's characterization of 703 relating to private communications and 702 relating to public communications?
absolutely, there is no, the statute in many places talks about public content. It talks about content that users consent to disclosure. So it's not like it was an accident that Congress just wasn't thinking about this. It carefully calibrated exceptions and rules for for disclosure of public content, for access to public content. It did not write such an exception in 2703. Why not? Because it recognized that when you're talking about government surveillance, you're talking about a whole different ballgame from private litigants. You're talking about the enormous power. Recall at the time the kinds of government surveillance that had been ongoing and growing at the time in the 70s and early 80s when Congress was writing this statute. Congress wrote about the ominous consequences of government surveillance, and it wrote special rules for government access here. And departing from that plain text not only would open the door to what Your Honor called the ominous consequences, even in cases where the government admits up front that it is trying to create a watch list of users who say things the government doesn't like, but it also threatens to intrude on the First Amendment rights of Meta's users and of Meta itself. This is essentially an investigation into whether Meta is living up to its editorial standards. The government says forthrightly in its brief, we want to watch over Meta's shoulder to decide whether it, quote unquote, failed or refused to take down content that it pledged that it would take down, because we think it made the wrong content moderation decision in light of its publicly announced editorial standards. That is a significant potential chill. And I think that the backdrop of the First Amendment concerns here, both Meta's own and its users, I think also helps to underscore why this case is not a matter of whim. This case is about a statutory scheme that carefully sets out rules the government must follow, that is intended to protect the interests of both the platforms and the users, and that no court prior to the Superior Court's decision here has ever thought would permit something like what the government is trying to do here, with respect to, particularly with respect to the non-public content that is covered, and with respect to user identities, which I heard my friend talk about wanting to be able to identify well-known or repeat offenders. If that's the subject of the investigation, they have absolutely no need for the identities of all the other users. And even with respect to repeat offenders, a unique identifier code would be more than sufficient for the government to be able to identify that a particular pieces of content were posted by one person. This is grossly overbroad, no match whatsoever to the interests that the government is asserting here, and endorsing the Superior Court's departure from the plain text, we would submit would open a massive loophole in the Stored Communications Act that would not be limited to situations where the platform is under scrutiny. It would not be limited to situations where maybe COVID misinformation seems like a worthy target of investigation.
All right, thank you, Ms. Carroll.
Thank you.
We'd like to thank the council and parties for your briefs and arguments today, and the case is submitted. Right, Ms. Carroll, you're free to exit our virtual courtroom. Thank you. All right, our next case this morning for argument is Metropolitan St. Matthews LLC et al. Versus District of Columbia. All right, good morning, council. Are you ready to proceed?
Thank you. May it please the court, my name is Thomas Locke. I represent the appellates MEPT, St. Matthews LLC and TFG 1717 Rhode Island Avenue property. If it would please the court, I'd like to reserve 4 minutes for rebuttal.
Thank you.
This matter involves the misapplication of the recording and transfer statutes, specifically 42-1103A and 47-903.
Council, may I jump in?
Yes,
On these two statutes, in your brief at pages 23 and 24, you suggest that prior to 2020, the District of Columbia did not interpret these two statutes as they are interpreting them in this instance. But I was wondering what support you have for that assertion.
well, we're not aware of it. We've researched both the case law and the tax statutes, and we're not aware of it. And we've requested both in the Superior Court prior to that, when we were seeking the appeal at the administrative level, and here in the appellate court for the district to identify any time.
We have a recent decision of this court in December of 2022, Design Center, the Design Center case. Although factually distinguishable, some of the legal principles apply here about how to read these statutes and how to determine what aspects of a transaction like this need to be taxed.
Well, Design Center was distinguishable in many significant and important respects. Most importantly, Design Center did not involve the assignment of a ground lease. Design Center involved the sale of land and the termination of a ground lease and the reversionary interest to the landowner, which allowed the participants there to avoid substantial tax,
Right.
70% of the consideration.
Right, and I understand the factual scenario to be very different, but the legal principles that I think are applicable from Design Center are the fact that regardless of the instruments that are used, and here the contention of the parties is that there was one deed transferring the office building developed on this property and the ground lease rights. And therefore, it's one transaction, only the consideration of 58 million should be taxed. But that seems to run counter to the legal analysis in Design Center and to the statutory scheme here that says the interests that are being transferred are what need to be taxed. And here there are two interests: the interest in the building itself, and the interest in the ground lease, which allows you to maintain the building on that particular land.
Yes,
And
sure.
the two statutes that we are looking at are 42-1103 and 47-903.
Yes, Your Honor. The reason those interests are different is that the assignment of a ground lease is very different than the creation of a ground lease. And the statutes recognize that difference.
Could you point me to the language in the statute? that
Yes,
you
Your
said
Honor.
Recognize that.
The statutes refer to the net or the consideration paid for the deed.
Which provision?
I'm sorry, Your Honor, that would be 11 or 42-1101 A1A and 47-903. Now, our position is that the assignment is addressed only with respect to a deed that conveys title to real property, and that's in A1A. And that should be taxed based on the consideration paid for the deed.
Right, that's 47-903 A1A. But right after it, 47-903A, it says if the interest in real property transferred is a lease or ground rent for a term, including renewals that is at least 30 years, the transfer tax will be computed. And that seems to be exactly what we have here. A ground lease that had a term that, even though it hasn't all been used, exceeded 30 years by far.
And the reason, if you also look at 42-1103 A1B and 47-903-2, both sections discuss a fair market value limitation. So what they're saying is the recordation tax shall be based on the annual average rent, provided that the amount to which the rate is applied shall not exceed the fair market value of the property covered by the interest transferred. Now, what's important is what the interest transferred is. And what we've tried to say, the district had brought in the legislative history on several occasions. And what we've said is, and the district mentioned Maryland and Virginia. Maryland and Virginia treat assignments of leases differently than creation of leases, as does New York City, Chicago, and numerous other jurisdictions.
Right, and I understand in the supplemental briefs, you cite us to a New York case, and in that case, the statutory language is very different from our case. And where there's only that one time initial taxation, the initial time the land and the lease or the building and the ground lease are transferred. And our statutory language is different, unless I'm missing a provision.
Well, I think it's not as different. I would agree that New York, Chicago, Maryland, Virginia, Los Angeles, and a whole host of other cities are quite specific that assignments are treated differently than the creation of leases. Frankly, I don't think the legislative history and our statutory language address this specific situation. That's why it's only recently that the district decided to apply this. And I believe they applied it because of the design center case. They said there's something funny happening in that case. 70% of the consideration is not being taxed. In our case, the entire amount of the consideration was taxed.
Well, that's not. Do you agree that the 58 million applied to the improvements is a fair valuation of the value of those improvements? In other words,
no, Your Honor.
What you want essentially is to have the transfer of the ground lease to be tax-free.
No,
Is that
Your
right or
Honor.
wrong?
That's not the case at all. The consideration that was paid, 58.8 million, was both for the building and for the ground lease. And let me explain that. We have an appraisal, which the district has not addressed in any of its briefs. We brought it up in the Superior Court and here.
Well, wait a minute. This is a different kind of argument, it seems to me. There were two interests transferred here, the buildings and the ground lease. The district's taken the position that the value of the buildings, if you accept the analysis that the two things have to be looked at separately, I thought that both parties agreed that the 58 million was a reasonable, was being paid for the improvements. That's not right.
That's incorrect. The appraisal.
That's correct or incorrect?
Incorrect, Your Honor.
Incorrect?
Incorrect.
Incorrect, okay.
The appraisal valued both the buildings and MEPT's leasehold interest in the property. So everything that MEPT sold to PFG was encompassed in the 58.8.
Yeah, but here's the problem that I have. Just say somebody has a house with a mortgage on it. And say the property is appraised at $1 million. The mortgage is for $500,000. Suppose somebody comes along and says, I want to buy your property. And you say, okay, you can have it. What are you going to pay? This guy says, well, I'm going to pay you $500,000 because for the remainder of it, I'm liable on the mortgage. So in effect, what I'm doing is buying your, if you want to put it this way, what's represented by the property covered by the mortgage for the mortgage payments that I'm going to have to make in the future. Now, that's probably never going to happen because, you know, but suppose, isn't that functionally what happens here?
No, Your
Is
Honor.
that the buildings part is separate from the ground lease, which in effect is by paying the ground rent for the remainder of the term, that's paying off the mortgage. That's what I'm paying for the continued use. But functionally, there has been transferred to me the property, the ground lease part, for this case, like 50 years, I think, 60 years maybe. And that is what the district wants to tax. Now, the problem is, how do you determine the value of a ground lease? And the district says there are various ways of doing it, but if you can't figure it out otherwise, here's the system to be used. Isn't that kind of where we are?
No, Your Honor, it's
Why
not.
not?
The reason is when the Archbishop entered into a ground lease with MEPT, the Archbishop, the owner of the land, had the land and was giving up something, its use of the land, so that the developer, MEPT, could develop the property.
Sure, and you paid a tax on the then value of the ground lease at the time it was created. But now that thing, that entity, the ground lease, is being transferred to another party, just like a piece of land is being sold to another party.
Well,
And so what I'm getting at is, if in fact part of the 58 million was paid for the ground lease assumption, if you want to call it that, how much?
well, we don't know.
And isn't that a valuation problem? And you ought to at least get some credit for that as against the formula.
But we know from the appraisal, the value of the total property. The appraisal said the value of the property was 59 million.
What do you mean by the
I thought the
property?
district said that the value of the fee unencumbered and the buildings came in at approximately $95,000.
I believe.
If you were to sell the
district said
property
no.
outright, free and clear with the building and the fee, you would go for about $95,000. Is that wrong?
That is wrong.
Why
First,
is it wrong?
it's wrong in the sense that MEPT doesn't own the property, so it can't sell property that it doesn't own. Second, the value of the property is approximately 25 million. Actually, at the time in 2019, when the appraisal was done, it was approximately 23 million. But the point.
But they're getting the entire value of the property except for the little value of the reversionary interest 60, 70 years in the future. Isn't that right?
No, Your Honor, it's not.
Why not?
Because the TFG does not own the property. It has to pay rent to the Archbishop for that property. It did not, MEPT did not own the property. It did not have the right to sell the property. The property might be valued at 25 million.
But they didn't
But-
sell the property. They sold the land lease, which allowed, which has value. And it was theirs to transfer because it was transferred to them, the land lease, not the outright fee simple ownership of the land. And there is value in that ability of MEPT to transfer it. And there's value that TFG, is receiving in that transfer. And
Yes, and that was identified by the appraisal at 59.1 million.
right, and then that's good, but then we still have the statutory language. And the statutory language says that the district can tax both the transfer under 47,903 at the time the deed is submitted to the mayor, the transfer of the deed to the building, and at the time of the deed, including a lease or ground rent term. That is at least 30 years. And I'm not understanding
Yes.
clearly your argument about how we ignore those two statutory provisions.
First, I don't think you're ignoring them at all. What's built into the statutes, and let's just be clear, unlike New York, Chicago, and all the other jurisdictions who clearly treat creation and assignment differently, our statutes don't deal with assignments. They simply do not mention the assignment of a ground lease in the context of these statutes. But second,
I mean, it talks about the assignment of any interest in real property as being taxable, just like any other transfer.
it does in the context of a deed in 49, I'm sorry, just want to make sure I quote it correctly. 42-1101A1A. But what's built into the statutes is the idea that there is a fair market value element to this. The city was not trying to say, we are going to make you pay more than you should pay, more than the value of the transaction.
Yeah, but I mean, in the creation of any ground lease, this would be true of an assignment as well. There tends not to be consideration paid for entering into the ground lease. It's a long-term consideration. You've bound yourself for 99 years to pay ground rent. But the value of that transaction is not $0. The statute makes clear that that's true. The statute tells you how you tax that. And you tax that as a percentage of the median ground rent over time. And I don't understand why. And I mean, I agree the statute is somewhat, I mean, it doesn't explicitly talk about assignments of interest in ground leases, but it does say roughly that we tax the assignment of interest in land in real property the same way we tax any other transfer of it. And so I don't understand why we wouldn't tax the assignment of a ground lease the same way as we'd tax the creation of it.
Well, multiple reasons really, but one, we tax the deed that's recorded. We're not taxing, and the deed in this case was the improvements plus the assignment of the ground lease for 58.8 million in consideration.
Yeah, but not for ground leases, though. It doesn't say it's the upfront consideration that you tax. For ground leases, you tax it by looking at the long-term interests that are transferred and doing an annual percentage of the annual ground rent, I thought.
Well,
And it wouldn't make sense to tax the consideration paid up front the way you might with an ordinary deed, because that number is usually going to be zero when you're entering into a ground lease. I'm sure there are some ground leases are structured with some upfront down payment, or, we'll pay the first 5 years in advance as consideration for whatnot. But generally speaking, the consideration you're paying for entering into the lease is really $0. Its value is quite a bit higher, and the statute contemplates that and says that's why we have to tax it under this totally different formula.
well, but again, the statute includes in it the consideration or fair market value component. Let's push the consideration aside, and we'll talk about fair market value for a moment. The district makes at least 3 different simultaneous arguments about consideration. They say no consideration was paid for the ground lease. They say the consideration paid wasn't enough. And then they deny that they ever said no consideration was paid. They say the consideration doesn't matter for some of the same reasons Your Honor just mentioned. But when you look at the statute, if there is no consideration paid, the rate for tax shall be applied to the fair market value of the real property covered by the lease or ground rent. And that is included both in recordation and in the transfer statutes. And specifically, although the transfer statute refers to subsections 2 and 3 with respect to determining the amount, the basis for the tax, subsection 1B includes the word and requires fair market value if there is no consideration. So if there's no consideration, you have to look at the fair market value. And we know that the fair market value was sufficient because under the fair market value test, there was enough that was paid. It was way more than the statute requires, and the district doesn't dispute that. Again, it is very important to understand that the appraisal, this was not a trick. This was not design center. We were not trying to do anything that was unusual in any way. This is a type of transaction that's happened for decades in the District of Columbia.
But I mean, I just want to push back on this sort of, you kind of make this appeal to practice in the district. This statute was amended, I believe, only in 2001 to apply for the taxation of ground leases that were more than 30 years. So the scenario that needed to come up for this type of case to arise was, since 2001, somebody would have had to enter into a ground lease that was greater than 30 years and then sought to assign it to another individual, basically in less than 15 years, which is not a great idea. I mean, you could have just entered into a ground lease of less than 30 years if that's how you wanted to do it, and you would have escaped taxation on the front end. So it doesn't strike me as odd that this situation, I mean, I feel like you're trying to say, the district has never done this before. So far as I can tell, the district has never failed to do this before either, because this scenario, I think, would understandably be a fairly new one, given the recent revisions to DC's code.
I disagree, Your Honor. There are many long-term ground leases that are entered into by developers who then develop the property and assign it.
Can you point me to one that would fit underneath this and the district failed to tax?
I don't have one off the top of my head right now, but I know that it happens.
This
if the
statute
court-
doesn't apply only to ground leases, does it? It applies to leases. If I have a piece of property and I've rented it and I'm the lessee and it's for 40 years, it's a lease. I own and I transfer that leasehold to somebody. Isn't it taxable under this? It doesn't say anything about ground lease. Why do we keep talking about ground leases? I know realistically, any lease more than 30 years is a ground lease, but conceptually, what's being transferred is the leasehold interest. And I think the problem that you have is that the district has rejected for transfers of ground leases for more than 30 years, the whole concept of consideration and instead put in a different mechanism to determine the value or the way in which a transfer of a long-term ground lease is going to be taxed.
Yeah, 2 points, Your Honor. First,
There we
you're
are.
correct that it applies to a lease, whether it's a ground lease or not, if it's over 30 years. But second, I think your hypothetical started with if I own property and then entered into a ground lease. That's a very different situation because you own the property. Here, this is not a situation where a developer or owner of improvements is trying to avoid. It's merely saying, we had the building, we had the ground lease, we had both appraised. The fair market value was this. Unfortunately, we could not get 59.1 million. We got 58.8 million. That's the value of the transaction. And the district, again, MEPT and TFG went to OTR and said, this is the situation. We're not trying to avoid anything. Give us your opinion. They gave us their opinion. We disagreed. We appealed. This is not the situation where we, like Design Center,
Right.
transferred a huge amount of consideration.
I don't think we mean to suggest that. And in my initial question about the applicability of Design Center, I think it's clear in my mind that the factual scenario in Design Center is very different than the one we have here. And I don't think anyone is questioning the integrity of the parties here in trying to effectuate this deal. I think we find ourselves with a statute that has been recently amended perhaps, and is different and is very explicit. And I think the way that the deal was structured, despite best intentions, does not comport with the statutory language that we have to interpret here. And nor does it comport with the language in other jurisdictions, Maryland, Virginia, New York, Chicago, that have been cited to the court, because those statutes in those jurisdictions are different from the language in our statute here.
They are different, but they reflect the difference between the creation of a ground lease and the assignment of a ground lease.
Right,
And
and our
because-
statute doesn't explicitly reflect that difference, and in fact, explicitly says something different.
I disagree that our statute says something explicitly different. I would say that our statute is at best vague on the issue. The fact that the District of Columbia has not been able to come up with a single instance in which something similar has been done. This is a very routine transaction. The assignment of the sale of improvements and the assignment of a ground lease over 30 years. It is a new position they've taken in part
Based on the new statutory language.
No, because that statutory language has been around for 20 years. I think it's a new position because they got burned in Design Center and they wanted to make sure that they didn't want to have another Design Center. But in an effort to avoid Design Center, they have overreached. And the statutory language does not support what the district is trying to do here.
All right, thank you, Council.
you,
We'll
Your Honor.
reserve your time for rebuttal as well.
Thank you.
Thank you, Your Honors.
All right, good morning. Council.
Good morning. May it please the court, Arjun Ogale for the District of Columbia. The District of Columbia applies transfer and recordation taxes to each transfer of a real property interest.
So has the District of Columbia government suddenly started taxing interest in leaseholds over 30 years in recent years and deviated from prior practice? I'm hoping you can respond to part of the concerns raised by your opposing counsel, Mr. Locke, that the district may somehow be differently and suddenly treating these kinds of routine transactions as he described them in a different manner.
Sure, Your Honor. So I want to emphasize that the district's argument in this case is about the meaning of the statute. In this case, this isn't a case about disparate treatment, discrimination against these taxpayers. It's a case about the statutory meaning here. Well, with that being said, the taxpayers haven't identified a single instance in which the district has treated similar taxpayers differently, and nor could the district find any such similar examples either. I will say that the district has taxed transfers and assignments of leaseholds in the past. Just in the past 2 years, it's taxed 3 different leasehold interests, the transfers of different leasehold interests. And post-dating this case, it taxed another similar transaction involving the transfer of both a building as well as a long-term ground lease. They were in separate deeds there, but in the same overall transaction. So this isn't something that the district doesn't do. I can't point you to any examples involving the exact same transaction predating this case, but that doesn't mean that they don't exist. I can represent to you that the district does, consistent with the statute, identify each property interest that is transferred and applies the tax statutes to those different property
Could you
interests.
so speak to the argument raised in the most recent supplemental briefs that other jurisdictions like New York and Chicago and perhaps Maryland and Virginia only tax the leasehold interest at the original acquisition or transfer of it and don't tax successive transfers of that leasehold interest? Why should those cases be persuasive to us as appellant argues?
Sure, I'm happy to answer that question. So unlike in those statutes, in our statute, there is no textual distinction between the assignments of leases and the initial creation of leases. So if you look at the definition of transfer and the definition of deed in 47901 and 421101, both of those definitions include the word assignment, which presumably means that assignments of deeds are included, or assignments of ground leases are included in the transfer and recordation taxes here. Now that's as a textual matter. As a policy matter, it also makes sense to tax not just the initial creation, but also the later transfer of a long-term ground lease. No one would make the argument that only the first sale of a home in fee simple is taxable, but when that home is transferred to other parties down the line, that isn't taxable. That's the same sort of situation here. What the district is trying to tax is the transfer of the long-term possessory interest, which in the council's view came quite similar to looking like fee simple because of the long-term possessory interest in the land. Now, I'll grant you that there are other ways that other jurisdictions do it. So Virginia, for example, New York and Chicago, they don't tax the assignment of long-term ground leases or leases. But that's a policy matter and the council just went a different way. I think the distinction
Is the district an outlier with respect to that and among other jurisdictions?
I'm not sure. I'm not sure whether there are any other jurisdictions that do it this way, but there are also other differences between the way other jurisdictions tax ground leases. For example, Maryland taxes any lease that's longer than, I think it's 6 or 7 years, whereas the district does 30 years, which is much longer. So there are less leases that are subject to the tax in the first place. So I'm not sure whether it's an outlier in that regard, but I think the textual distinction between, say, for example, the Virginia statute, which the council did have in mind when it was drafting this statute, I think that textual difference speaks volumes about whether assignments are taxable in the district versus whether they are in other jurisdictions.
What is the textual? I mean, so I take it we're talking about Virginia Code 58.1-807.
That's right.
When I read that statute, it's not at all clear to me if they would tax the transfer of a ground lease, but then they passed a regulation that says, well, we interpret it as saying, you know, they pass, what is this regulation? 23 VAC 10-32080 that says, well, an assignment of a lease, if it's already been paid, it's just not subject to tax if there's no increase in the amount of the principal obligation upon its transfer. I actually don't see I'm not sure there's a statutory hook for that. That seems just to be have been an administrative interpretation of a statute that effectively saying, it wouldn't really make sense to tax it again upon transfer. Do you disagree? Do you think that the statute itself says you don't tax that?
I think the statute, what it does say is that once a recordation tax has been paid once, it doesn't have to be on a single lease. It doesn't have to be paid again. I think there are different ways to interpret that. That's just the way that Virginia has. And for purposes of our argument, we're just focusing on the fact that the District of Columbia has no such statutory language saying that once a deed of lease is taxed, it won't be taxed again. So I do think there are different ways to interpret that, as Your Honor mentioned, but I just don't think that we focus hard enough on the Virginia statute to make those sort of differences. And we will grant the taxpayers that maybe Virginia treats them that way, but the district doesn't. There's a few more points I want to make.
Part of the reason that I ask about
Sure.
the regulatory interpretation is, well, one thing you've argued is, well, look, if this is close and you can't tell, defer to OTR's reasonable interpretation, which is also where I think opposing counsel's argument about past practices comes into play, because what he might say is, well, you shouldn't defer to that interpretation. It's a newfangled one. It's one that they've come up with only in the last couple of years, and they apparently held the opposite interpretation for 20 years, which strikes me as a question that we don't really have evidence on. I mean, it sounds like neither party can point us to a case where the district has or hasn't done this before. So if this is a new interpretation of OTRs, do you think it's still entitled to deference? If it's contrary to a prior interpretation, do you think we still afford the same amount of deference to it?
Sure. I just want to emphasize that our first argument is about the text of the statute, but assuming some sort of, assuming that Your Honors think that the text is ambiguous, I do think that this is an interpretation that deserves some deference. I think this sort of interpretation reflected reasoned decision-making on part of OTR. It wasn't an interpretation they came up with on a whim. I think they went through the statute, they identified each distinct property interest, as this court would later say that they're supposed to do in Design Center. They went through each property interest and then interpreted the plain meaning of the text based on the different property interests that they found. Then, to double check their work, they also did a reasonableness check on whether their interpretation was leading to some sort of absurd amount. Basically, they took the value of both the building, the assessed value of the building, and the assessed value of the land, and they analyzed what the value of that would have been if both properties were transferred in fee simple, and they came to a number of about $92.3 million. The tax was applied on $97.5 million. So that was 5% within the assessed value of the total property that was transferred, and they thought that that was a reasonable interpretation.
Now,
So
when you say the assessed value, I know your opposing counsel made a point a couple of times about the fact that they, meaning MPT, MEPT, and the appellants made a point of assessing the reasonable value of the property and the land, if I understood counsel correctly, for 58 million. So is this dispute really a difference of assessments, and evaluations of the land and the lease, or is the district's position that the 58 million really was not consideration for both?
Sure. So I think just so I have your question correctly, your honor is mentioning the appraisal that opposing counsel brings up. So I don't think that appraisal is relevant for a few reasons. The first is that the text of the statute is pretty plain and it doesn't discuss any sort of appraisal. The statutory provision that the district used here talks about the assessed value of the land, and that's based on OTR's assessment of how valuable the land is. And that in total came to $92.3 million. The second reason is
with the improvement on it.
With the improvement, the land and the improvement, yes. The second reason is that the opposing counsel didn't raise that appraisal anywhere in their opening briefing, except in their statement of facts in a very cursory sentence. So the district's position is they've forfeited any sort of argument that the property overall was worth more than was worth only $59.1 or $59.1 million. But even if one were to look at that appraisal, if one were to take a close look at it, on JA 132, it says that the appraisal is of the leasehold interest of the subject. And then later it defines, also on JA 132, it defines the subject as the building, which is the good quality 10-story office building in very good condition. I don't think it talks about the land at all. There is a separate page, I think that's JA 162, that talks about the ground rent that's due on the site. It describes the land as the site, but nowhere in the appraisal does it talk about the land and the building, the fee simple, or just the assessment value of those two being only $59.1 million. So I don't think that's an accurate assessment of what that appraisal is.
Can you remind me, did the district's tax assessment value of the land, what portion of the 92 million did that represent?
Of the land?
Of the land.
I'm not sure percentage wise, but the number
amount
was $25.8 million was for the land. And then the building, this was for tax year 2021, the building was $66.5 million. So in effect, I think the transaction reflected the $58.8 million that were spent for the building, that reflected a little bit less than what the building was actually assessed for. I do want to.
I'm still not clear. Because I had misunderstood, I
Sure,
guess, what the parties had agreed to.
Sure.
The assertion is made that the $58 million covers not only the building, but also the ground lease. But is it the position, if in fact a portion of the 58 million was paid for the ground lease, why would they do that? I suppose because the terms of the ground lease are really very favorable compared with what a comparable ground lease would cost these days. I mean, that's the normal value of a leasehold interest, is the difference between the present rent and the rent you'd have to pay otherwise. And is it the position of the district that it gets to tax not only as if the 58 million covered the ground lease and the buildings, that it is also entitled to impose another kind of valuation contained under the statute? Or does the taxpayer at least get a little bit of credit against the statutory valuation of the leasehold for what it paid for that leasehold?
Your Honor, the district's position is that the $58.8 million that was paid in the transaction was attributable only to the building, and that the value of the ground lease was reflected only in the future rent payments. We take that position for a few reasons. I think the main reason is just what the building was appraised.
It sounds like you have a little factual dispute maybe operating here that wasn't addressed.
Your Honor, I don't
Possibly. I just don't know what the district's position would be if it should turn out that, yes, indeed, a little bit of that was paid for the ground lease because the ground lease was very favorable.
I don't think that any of the $58.8 million went toward the ground lease. The taxpayers in a separate proceeding before the Real Property Tax Appeals Commission essentially conceded that the $58.8 million went only toward the building, only toward the improvements, and that none of it went for purchasing the ground lease from MEPT. So that's one piece of evidence that we can point to. And we can point to the district's tax assessment for tax year 2021, which valued the building at $66.5 million. So the taxpayers actually paid less.
Well, it's a relatively minor point because obviously most of the consideration, if not all of it, went for the improvements, not for the ground lease, because the ground lease was essentially zero value as far as parties were concerned, except let's see, the buyer had to get the ground lease. But if I understand the basic position of the district, it's this. Look, at the end of the day, the transaction started with somebody owning a building and a ground lease for 60 years. At the end of the day, another entity had the building and this ground lease. So what the district says is there's been a transaction, not only of the building, but of the ground lease. In fact, virtually the entire remaining term, a very long term, which has a whole lot of value because they have the right to occupy that property for a very long period of time. And we want to get, since there's been a transaction that has resulted in a significant change of ownership, we're going to tax it. Now, it's very hard to tax it because to figure out its value, because it all involves, like a mortgage, long-term payments. But we're going to sort of try and figure out what that value is. And we have a formula that exists, which nobody seems to challenge in the abstract. They just don't want it to apply at all, right or wrong.
That's exactly
Do I
right.
have it wrong? I mean,
No, that's exactly
kind of
right,
the
Your
way
Honor.
it seems to me. The council said there's a huge gap here because major rights in property are being transferred with no tax.
That's exactly
And
right.
we want to tax every transaction that takes place in which A owns Blackacre and when B owns Blackacre, a tax is paid. And the only difference here is the Blackacre happens to be a long-term lease rather than Blackacre itself.
That's right. And just to add a little bit to that, the district tries to tax each transfer of an interest in a real property. Here, if you take a look at what actually transferred hands, which was first the building and second the land, the combined value of that was $92.3 million. It just doesn't make sense that only $58.8 million that was consideration paid should be taxed and that the future rent on that property should go untaxed. I see that I've exceeded my time, so if the panel has no further questions, I'll yield.
Thank you.
We respectfully request that you affirm. Thank you.
Thank you, Your Honor.
Council, we've reserved a couple minutes of rebuttal time for you.
Yes, first, the tax was paid on the consideration for the deed. That's what the statute requires. That's what happened here. The consideration for the deed, which the district does not dispute, is a fair value for the interest transferred was $58.8 million. There's no doubt about that. The district has never said that's an insufficient consideration for this transaction. The
Well,
deed
but
that was,
consideration is an interesting concept. I mean, if we go back to property or contract law, you could. Consideration could be $1. It just has to be something of value to recognize that you are seeking to be bound and exchange, engage in this particular transaction. And similarly, the assessed value can vary and is different from the fair market value. So
Your Honor,
we're talking different, almost apples and oranges.
well,
aren't we?
the statute addresses nominal consideration and has a standard for dealing with that. And no one argues that the consideration paid for this transaction was nominal, not even close to nominal. Again,
Well, I don't think there's any argument either that the assessed value of the land or the building by the Office of Tax and Revenue is not a fair assessment of the value.
the assessed value of the land, the problem is the land was not transferred.
No, the assessed value was
The
the
assessed value,
leasehold interest in the land.
that is not what the district has established. That's not what they argue. The assessed value is the amount of tax that the Archbishop owes annually for the value of that land. And that was the value, roughly 25 million. It was actually 23 something in 2019 when this transaction occurred. The point is, that's the value of the ownership of the land. The Archbishop has the obligation to pay that value. Now,
Right, but
through
the
the
transfer tax that's due is a formulation. It's not the exact assessed value of the land. I believe the statutory language lays out the formula from which you extract or project out the value of the leasehold interest in the land.
right, and what happens with the creation, when a landowner transfers the interest of the land to a lessee, then it's determined based on the annual rent, which if that can't be calculated, is 150% of the value of the land, because the assumption is the land value is going to go up. Let me just address a few other issues that council mentioned. It was noted in the past 3 years that district has applied this new tax methodology in our view, but they can't cite to a case prior to the past 3 years. What's important about that is that shows that what I'm saying, transfer of improvements and a ground lease happens. It didn't just start happening in the last 3 years. It's been happening for decades. So the fact that they can say they've done it in the last 3 years means that, and they can't cite a case prior to that, suggests that they didn't apply it prior to that. They argue, the district argues that OTR is entitled to deference. However, if you look at the various arguments that the district has made and abandoned in this case, it's really remarkable. They come and they go. In the opposition, they ignored the fee simple argument that they made before the Superior Court. In the supplemental reply and design center, they bring fee simple back into it. By the way, fee simple is not in the statute. There's nothing about fee simple in the statute in terms of how this is going to be decided. Let me just say that the taxes on assignments in New York, Chicago, and other cities, it's not that they aren't taxing the assignments. They're taxing them based on the consideration paid, which is what we're arguing here. The consideration paid reflects the value of the transaction. So when New York taxes the creation of a ground lease, it's taxing that differently than the assignment of a ground lease, because the value of that transaction is different. And while our statutes don't specifically address that issue, they don't really address the assignment of a ground lease at all. They could have, they didn't. The legislative history is silent on that point. We're not suggesting that assignments shouldn't be taxed or arguing that they should be taxed based on the consideration that was paid, which is supported by the appraisal. That appraisal, and I can go through it in detail, but we have numerous citations to the appraisal and the use of leasehold. It is not that the appraisal was solely for the building improvements. The appraisal again and again refers to the leasehold interest. Sorry, Your Honor, if you just give me 1 second, and maybe close to the end. Oh, there was the mention of the assessment of the property tax and the appeal. And this is another example of a newly created argument by the district, not OTR, but by its lawyers, that said, we are somehow stopped from arguing the value of the leasehold and the consideration paid for it and the improvements. And that was an argument that was made in the Superior Court, abandoned by the district in the appellate court, and now they brought it back here in this argument. Frankly, we're surprised to hear it because, again, the assessment of property is paid or is owed by the owner of the property. That's the Archbishop. Through the lease, the lessee is obligated to pay that tax, but it's not taxed on that basis. It's taxed not based on the value of the lease. It's taxed based on the fee simple ownership of the land. Thank you, Your Honors.
Let me just ask you one question. Would you say that in a transaction, the fact that somebody is relieved of an obligation to pay a very large amount of money for a number of years in the future is not a quote unquote consideration from the point of view of both purchaser and seller?
It's not something that the district.
We ignore that. We ignore the assumption of the debt in effect.
Well, Your Honor, it's much like saying, to use your example of a homeowner and mortgage type of situation. If a homeowner sells a property, a house, and they no longer have to pay mortgage payments, we don't tax them on the value of the mortgage payments that they're no longer making. And in this circumstance, although we no longer, MEPT no longer had to pay the Archbishop the rent, MEPT no longer gets to collect the rent from the tenants of the building, which more than offsets the so-called reduction in liability. So we simply do not tax the reduction in liability. And honestly, the district have not supported that argument. That was the reasoning of the Superior Court.
All right, thank you.
Thank you.
We thank both counsel and the parties for your briefs and arguments today.
All right.